Hello, my name is Kevin. I am an English lawyer. I have been practicing law in Thailand for about 10 years. I know everything there is to know about making a will in Thailand. Let me give you a few pointers to consider when thinking about making a will in Thailand. Consider first, where are your assets? In your own country, Thailand, or both? Next, consider to whom you will leave the assets in Thailand and to whom you will leave the assets in your own country. These people are your beneficiaries. Will they be the same beneficiaries in both Thailand and your own country? Then think about whom will be the administrator of your estate. That person will act as if they are you when you have unfortunately passed on. Administrators in Thailand are called executors or trustees in some other countries. You decide to appoint an administrator living in another country to be administrator of your estate in Thailand. The administrator will have to be present for a court appearance in Thailand and also to sign every time an asset or money is released. This may prove impossible and expensive for some people who work in another country to have to travel repeatedly to Thailand. You do not strictly have to make one will for Thailand and one for your own country. One will for both countries will suffice. However, it can make things easier if you have different beneficiaries and different administrators, executors, in different countries, to make one will for each country. That makes matters much simpler for your administrator when you have passed on. You may have been told that you must write a Thai will in the Thai language. That is not the case. In fact, it can be a very bad idea. I had one case in which the will had been written in both Thai and English language. Not by a British law company, I may add. The Englishman had signed the Thai will. Having read the English, he could not read Thai. The probate office in Liverpool, England, adopted the stance that because the will had been signed in Thailand, the Thai language in the will was definitive, ignoring the English language in the will. The probate office in England then asked British law company in Pattaya for a certified translation of the Thai language in the will into English language, which we did. The translations did not read the same as the English in the will, causing obvious problems for the beneficiaries and the administrator. The beneficiary in a Thai will can also be the administrator. In fact, if there is only one beneficiary and they live in Thailand, it makes sense for the same person to also be the administrator. It is worth considering executing two identical wills. Some years ago, a recently bereaved Thai widow came to the British Law Office in Pattaya for help with a photocopy of a will that we had written. She could not find the original. We also had a photocopy of the same will in the file. Photocopies are not accepted by the Thai courts. We have at British law adopted the policy of producing two original identical wills, both signed and witnessed at the same time. One for the client to keep and one kept in our file. I leave you with this thought, that if you were to die intestate in Thailand, that means dying without having made a will, Thai law requires your assets are distributed to your parents and all your relatives in set proportions, even though your relatives are probably living in another country. Your wife will be at the bottom of the list, and any girlfriend or boyfriend will not even be in the list. You really must execute a valid will if you live in Thailand. At British law in Pattaya and Jontiem, we consider this to be of the utmost importance. If you die without a will in Thailand, it causes such a big problem, which can be avoided for such little cost. British law charge only 6,000 baht whether the will is for Thailand or your own country. Be sure to talk to me at British law in Pattaya or Jontiem. It is free to talk. I hope this has been helpful. Thank you. Kevin Harper, British Law Company, Pattaya and Jontiem, Thailand.